All right, we're ready now for our last case, Hensel versus Taplin.
Your Honors, Counsel, good morning. May it please the Court, my name is Robert Siegel. I'm counsel of record for the appellant Tina Hensel in this case. This case involves a child with ostensibly two parents, a biological mother and a birth mother. In the trial court, Ms. Hensel, the appellant, is seeking an adjudication of her rights as the parent of this child. A significant portion of this case has to deal with the right of privacy under the Florida Constitution, found in Article 1, Section 23. A significant question that's been raised is, from where does this right derive? Clearly it's stated in the Constitution. Clearly all citizens in the state of Florida are entitled to...
Do you think that's your strongest argument in this case, right of privacy issue? Is that your strongest issue?
I think it's a very strong issue that it needs to be determined on the trial.
That's your best argument? You feel that's your best argument in this case?
I feel it's a very strong argument,
okay.
Yes, Your Honor.
All right.
There has not been established from where the right derives as to both of these parties. None of the cases...
Doesn't the right of privacy in the parental context derive from the fact that someone's a legal parent?
What I've been able to discover is under Chapter 382 appears to be the only section of the Florida statutes that creates the notion that a mother is the birth parent. There does not appear to be any other legislative enactment that creates any additional rights beyond that. And Chapter 742 creates, unfortunately, the only mechanism whereby anybody else can establish a right to parent a child. And it is the contention of the appellant that, as applied, 742.10 is unconstitutional, and it precludes her from seeking an adjudication under Chapter 742 that she is entitled to parental rights. And it gets back to the question, then, of whether the rights of the birth parent...
Is your argument that all biological parents have privacy rights as parents under the Florida Constitution?
Yes, Your Honor.
So that means that a sperm donor would have the same rights that your client would.
No, a sperm donor is a particular class of individual under Chapter 742. In those situations where parties enter into a gestational surrogacy contract, those individuals are clearly defined. They're defined by statute. They're defined by the terms of the agreement.
Your client did sign the quote contract at the time of the donation of the egg, though, right?
Consent form.
Respectfully, we're not referring to it as a contract. It is stated as a donor consent form. The affidavit provided by the doctor that performed the procedure indicated that this is a standard form that is applied in his practice for purposes of undertaking these procedures, and that it was not tailored to the specific circumstances of this case. And those facts presented to the trial court as unrebutted facts.
The problem I'm having with your argument is the same problem I had when I read the brief, and that is that I'm trying to figure out a legal analysis under any constitutional provision that's sort of a sound legal analysis, and your approach is, I have a constitutional right in general, and we're talking about facts, we're talking about, but I can't really pin down, this is the legal analysis that gets me to where you want to go. I just don't see it. It's all sort of broad generalities. You want to maybe try to help me with that?
It was initially the intent of the parties that they were going to raise this child together.
Let me interrupt.
Yes, sir.
See, I think that the more interesting analysis, not the constitutional one, because I don't think that really flies, to be perfectly honest, but I think you have a very interesting contractual argument, which I think is where you're about to hit. At least I think there might be a contractual argument that's sort of bound up with the whole constitutional argument that you're asserting.
Yes, sure. One of the issues that we had asked the trial court to raise was the issue of whether this was truly a donative situation. And it's been pointed out in Appley's brief that there were a number of circumstances that have been alleged in the second amended petition upon which the court ruled, suggesting the relationship between these parties. And it wasn't alleged so much to establish a psychological parent, which issue has been largely dealt with by the courts, and it's not anything that the courts are willing to accept here. However, it is relevant to whether there was a donative intent to the extent that the appellant could be considered a donor in this case. And it respectfully suggests that appellant was not a donor, that it was the clear intent of these parties that they would have equal rights to this child. And what the trial court needs to do is...
Down that avenue, why wouldn't the general parole evidence kind of rules apply? I mean, why should a court look behind a document that's absolutely clear and unambiguous and say, and allow testimony that impeaches what she signed? I mean, her testimony is, I absolutely did not mean that, but it's what it says, it's what I signed, I knew I was signing it, but I didn't mean it. Well, I mean, courts generally don't look behind documents to take parole evidence to attack a document like that. I mean,
without an ambiguity.
Completely unambiguous. Clear?
There appear to be internal inconsistencies in the document itself, and in considering the entire record maintained by the doctor, it was clear that when the procedure was undertaken that he had manifested to them, they had manifested to him their intent to raise this child together, and that was part of the treatment notes, that was part of the treatment procedure, and I think the court should entertain the parole evidence in order to determine what the true intent of the parties was, particularly as this is not a contract. Both parties did not sign the same document.
So if someone goes into a hospital and signs a consent form saying, I understand those risks, should we let them come in and say, no, I didn't mean any of that. I wasn't willing to accept any of these risks whatsoever, and so the hospital should be liable because I just didn't mean what I mean, when you're asking us to basically create new rules of law, and we have to think about all the permutations and how this is going to apply in other cases, and again, it's all these generalities, and I can't put my hand on a rule that you're asking, solidify, okay, this is the rule of law, this is where it derives from, this is how it's consistent with other law, or this is why you should get there, and this is what it would mean in other contexts. I mean, I'm really struggling with...
As are we all.
Yeah.
I must confess that I do as well. There's no decisional law that sets out a procedural framework for evaluating the situation. There's a ton of cases that you can say, it's not this, and it's not this, and it's not this, but there are no decisions where, in the context of these sorts of cases, you have the Wakeman case, the La Maritada case, to a certain extent, the Budnick versus Silverman case, and those all deal with a situation where the birth parent and the biological parent are the same person. And frankly, the best that I can do in terms of existing law is to suggest to the court that none of these cases apply, and that there is no way to distinguish the two parties in this case in terms of what their rights should be to this child.
What is the rule of law that you think we should announce?
I think the court should find that Chapter 742.10 can be used as a mechanism for a parent to establish rights to the child, where there's a demonstration that parent is the biological parent to that child.
And how do we do that without rewriting the statute?
It would require the court to make a finding that statute is unconstitutional.
Okay. And what theory, under what theory, what constitutional provision and what theory should we find that unconstitutional?
In the situation of a couple involving a man and a woman, both of those parties have the opportunity to establish their rights to parent that child. Under 742.12, a father can submit himself to scientific testing if it's established that he's genetically related to that child. All of the responsibilities and all the rights attendant to parenting a child attached to him, whether he wants them or not. And those cannot be...
Not if he's a donor, not if he's a sperm donor.
But again, we get back to that issue, is a factual issue as to whether or not she actually is a donor.
I mean, there's no question factually that she is a donor, and there's no question that she intended things other than what she said she intended when she assigned that consent form. I mean, I don't think there's any factual question about any of that.
I respectfully disagree in terms of like I said, the entire package and the affidavit provided by the doctor suggests that there was no donative intent. It was not her intent to enter into this situation.
Did the doctor testify why he had them sign the document then?
His affidavit was that this allowed him to proceed with the procedure The idea being that she was informed of the risks of actually undertaking this procedure, the medical risks that came up in terms of what could happen to her physically in the event that the procedure went wrong.
Do you think when the legislature enacted Chapter 742 that they envisioned a situation like this would apply to
No, Your Honor.
the provisions of Chapter 742?
No, I don't.
Isn't that really your better argument that, the legislature never envisioned this situation, therefore never intended Chapter 742 to apply to a situation like this, rather than your constitutional argument that, well, the statutes are unconstitutional?
At the risk of arguing against myself, 742.10 does indicate that it is the only mechanism whereby parentage can be established. Perhaps it doesn't apply simply.
But if that's the case, and the legislature never envisioned that a situation like this would exist when they wrote Chapter 742, wouldn't it make a proper argument to say that, well, the legislature never intended Chapter 742 to cover a situation like this because they never envisioned this situation when they wrote the statute?
Yes, as long as there's a procedural mechanism whereby appellant can get into a trial court to have an adjudication of her parental rights.
Well, if for example, we say for purposes of argument that the legislature never intended, because they never envisioned Chapter 742 to apply to a situation like this, and we find no legal precedent rendered by a court in terms of a judicial decision that covers this situation for us to follow, what then should this court do? Would this court then be free to come up with its own remedy?
I think the appropriate thing.
And how would we do that?
I think the appropriate thing to do would be to remand it to the trial court with instructions to allow this to proceed to an evidentiary hearing, allow the trial court to then determine whether or not the mechanisms that are available will allow this adjudication to occur, have it go forward in a full adjudicatory proceeding, and then review it if necessary at the end.
Well,
but it should not have been dismissed on summary judgment.
Pardon?
It should not have been dismissed on summary judgment.
Counsel, I'm looking at the informed consent form, and it reads, I, the undersigned, forever hereafter relinquish any claim to or jurisdiction over the offspring that might result from the donation, and waive any and all rights to future consent, notice, or consultation regarding such donation. I agree the recipient may regard the donated eggs as her own, and any offspring resulting therefrom as her own children. Now, why wouldn't it have made sense for the parties to simply strike that out, or to add or to modify it so that it reads that they both intend to be parents to this child? I mean, what I'm really struggling with is that the documentation strongly favors the appellee in this case, and it could have been modified by the parties to reflect their true intent if that's what it was. You see what I'm saying?
Yes, sir.
I'm really having. I mean, this is an important case, and it's a very, very interesting case, and I'm really struggling with it. And both sides should know that. If it's not obvious already, both sides should know.
Let me ask you how this is different from the Wakeman versus Dixon case. I mean, in that case, basically, it was very similar. Factually, I guess the only distinction, and I don't know if there is a legal distinction, is that no partner was a donor of genetic material, so no one can claim that they were a biological parent. But I mean, in that case, basically, the court struggled and said the legislature really hasn't addressed this. In the concurring opinion, the judge said the legislature really needs to address this. It's a really important issue for citizens of Florida. But I mean, it seems like it is a public policy kind of issue that the legislature needs to address, but I don't know how we as judges can basically write the statute to deal with something that needs to be dealt with.
Well, we fall back again on this constitutional argument that there is no way
I mean, the problem seems to be just like it. I mean, the only difference here is that your client donated genetic material, so she can make biological. But I mean, I don't see what the constitutional problem is with a statute that treats all donors basically the same. I mean, it basically says that donors of genetic material don't have parental rights. I mean,
well, again, at the risk of beating the dead horse, we do not consider this a donative situation. Assuming that it is treated as a donative situation, there are significant problems.
Says, I have requested that the facility and reproductive medicine center for women, its agents, and its employees assist me in my desire to donate oocytes in order to help another couple achieve a pregnancy.
But see, these are some of the internal inconsistencies. It wasn't to help another couple, it was to help this couple. And even under Applee's interpretation of the agreement, it would have been merely to assist Applee as opposed to a couple. In paragraph 6, it talks about the recipient, in this case the Applee, being financially responsible for all of the costs. But that isn't what occurred here. The factual circumstances are such that what is contained in this document do not match with what actually occurred and what the intent of these parties was. And the evidence and the testimony that was presented to the trial court at the very least created a factual issue that needed to be resolved by the trial court and wasn't in
so
the order.
your primary argument is, getting back to the constitutional issue, this is unconstitutional because it deprives her of her right to privacy to procreate?
Yes, sir.
Well, and the right to have access to the child.
To parent that child in every way. I'd like to reserve the remaining time for rebuttal, please.
Good morning. May it please the Court. I'm Michael Jones. I represent Applee. I'm with the Wheelock Law Firm. I have the privilege of being here. I believe that this is a situation that the legislature absolutely knew what it was doing and absolutely has created.
Do you think the legislature envisioned this situation when they wrote Chapter 742?
Yes, Your Honor.
What in the statute leads you to that conclusion?
Your Honor, what leads me to that conclusion is the definition of a commissioning couple in a surrogacy situation, which is Section 742.113 paren 2, in which a commissioning couple by definition is a man and a woman. It is a clear legislative intent that a commissioning couple can only be a man and a woman.
Well,
by legislative interpretation.
It seems to me that that's evidence that the legislature basically intended the statute to apply to situations where you have an infertile couple, a man and a woman, and in order for them to procreate, they need the donation of a sperm or an egg or both. But I didn't find anything in the provisions of this chapter that would lead me to conclude that the legislature ever envisioned this situation when they wrote the statute, or any part of 742.
When you read the entire Florida law, both the Constitution and the statute, and we do read the statutes in conjunction with each other, and to make sure that they all make sense together, there's a very clear intent, both in the Constitution, voted in by the people of the state of Florida, that there is no same-sex marriage. There's a very clear statutory provision.
Well, we're not talking about marriage here. We're talking about whether a woman who donated her egg to her lesbian partner has any rights to visit the child and to help parent the child and to help raise the child as a parent, co-equal with the woman that actually gave birth to the child.
It's very clear.
And I have a hard time envisioning that the legislature actually thought about this situation when they enacted the statute. And then if they didn't, then what is this court to do? If we conclude that, well, the legislature never really envisioned this situation, and if they didn't envision it, then they couldn't have intended that the statute apply to this situation, then what is this court to do? Is this court free then to provide a remedy and ask the legislature in the future to address the issue? Or are we just basically stuck with the statutory scheme that we believe the legislature never intended to apply to this situation?
Your Honor, even if the legislature never envisioned this particular fact pattern when they created this statute, the overarching, and this is my point, the overarching statutory scheme of the state of Florida does not favor same-sex situations, and we have very clear case law that a contract is not enforceable for contact in this sort of situation. That's why Judge Monaco's point, even if they mark through the...
I'm not particularly impressed with the contract, because it seems to me that contract was basically intended for a man and a woman who go to a sperm bank or seek help with egg donations. And the doctor clearly testified that was not the intent of these parties. These parties had lived together. They fully intended to raise this child together. Everything that they did before, during, and after manifested their intent to raise this child together. And clearly, the doctor testified that that's what he thought their intent was as well, and that he had them sign that form basically to advise them and have something in writing that they were aware of the risks involved. So I'm not really impressed with the contract that was signed by these two ladies. I want to know whether the legislature intended Chapter 742 to apply to this situation. If it didn't, and there was no legislative intent that it cover this situation, what is this court to do? Does this court fashion a remedy, or does this court simply say, well, since the legislature hadn't spoken, there's nothing we can do, and move along that way?
Your Honor, I believe that intent is not the issue. I think the legislature has spoken. Even if the legislature has not spoken, this is a determination for the legislature to make. The legislature has made very clear determinations as to what it believes is the proper relationships and rights of donors. And it doesn't matter whether you're donating sperm or ova. The cases are very clear in both situations that a donor does not have rights.
And maybe this is the troubling argument. The troubling part of that argument to me is that the statute does allow a male to donate sperm and then become a father. There's a mechanism for that to happen. But I don't see a mechanism for a woman to donate an egg and become a mother.
Well, I'm not sure that there is a mechanism. I think that once the sperm donor has waived the donor.
No, he can enter a parenting agreement. I mean, there is a provision in there for him.
For a specific thing, for a parenting agreement. And
right.
That, again, is very clear that if the legislature intended that, it's up to the legislature to make that action. The case law is very clear.
But what happens in situations where the legislature doesn't speak to a specific issue? What is this court supposed to do then?
Don't we fall back on the common law?
Right.
Of course, Your Honor. And you fall back on precedent and common law and
precedent. But we don't have any precedent either, do we?
We do not have a case, Your Honor.
Okay, so why wouldn't it be a fair and equitable resolution of this case to say that both of these ladies should have visitation with the child and should share responsibility to raise this child in terms of child support and in terms of visitation and all the other things that go along with it? Why wouldn't that be a fair and equitable resolution of this case? And then tell the legislature, if you think otherwise or if you think we're wrong, then go ahead and act and say so.
Your Honor, the reason that is not a fair and equitable situation is because then you do not treat the sperm donor fairly and equitably. You do not treat the person that is married to the parent of a child fairly and equitably.
Why should the birth mother who got the egg from her same-sex partner have any greater rights than the same-sex partner that gave her the egg so that the two could procreate in the first place? Why should one have any greater rights than the other?
That's because of the United States Constitution and the Florida Constitution, Your Honor. The
privacy right. The United States Constitution tells us that one should have greater rights than the other.
The privacy provisions and the case law of the United States Constitution provide that the actual birth parent has absolute rights over anybody that is not a birth parent.
All right. Well, suppose these two people, and I think this is probably at least implicitly the case. I'm not so sure it's explicitly the case. Suppose these two ladies had a contract with each other, and the contract was, I'll donate the egg, you become the gestational mom, and we will both be mothers to this child. Right. Suppose two promises certainly supported by consideration.
Which is exactly what happened.
Which is exactly what happened.
Wakeman, and it was held to be unconstitutional, Your Honor.
So why isn't that contract enforceable?
It's not enforceable because it is the public policy of the state of Florida is that we're not going to enforce those kinds of contracts. We don't enforce them in Wakeman.
And we would have to we would have to conflict with Wakeman to get to a different result there, correct?
Not only would you have to conflict with Wakeman, you would have to conflict with Lamarata, which is the case of which a sperm donor who waived as the sperm donor then entered into a contract.
Did either one of those cases involve two women involved in a same-sex relationship, one donating the egg to the other so that they could both be parents?
No, but that's not a distinction that creates, that is not a fact difference that creates a distinction and a distinguishability in the case. And I'll be happy to answer that, Your Honor.
Go ahead.
The difference and the reason that it doesn't create a situation is because it's the fact that you're donating biological tissue. And that is where Lamarata comes into play, because that was male genetic material that was donated. And in that situation, we have the privacy right attaches to the birth parent, and it's very clear that it attaches to the birth parent, and the mother is always the woman that gives birth, with one exception that is statutorily created, and that one exception is to have a contract for gestation. And that was statutorily created and has to be statutorily created.
I have a hard time envisioning that this was a donation situation, under the general definition that we would give a donation situation in cases where you've got a man and a woman. I don't think this lady ever intended to donate her egg to the other woman and then release all of her rights to it. She gave the egg to the other woman so that they both could share in being parents to that child. She didn't donate the egg just to give it away and for her to walk away and to lose all parenting rights to the child, did she?
Intent doesn't matter, respectfully, Your Honor. It doesn't matter.
Well, let me ask you that. The judge didn't make that finding in any respect, correct? I mean, the judge didn't make any finding as to donative intent.
No, because he
so, I mean, there would be no way to go in the direction that Judge Sawai is suggesting based on findings of the court, because there weren't any on that issue, correct?
That's correct, but...
Let me ask you this.
Well, then how was summary judgment appropriate?
Wait, one at a time, guys.
Yeah. And let me ask you this. Don't you agree that it was error, at least for the trial judge, not to address the constitutional issues that were pled and argued?
The judge did address them. He said there was not a constitutional issue, and he upheld them. I believe was the situation.
I mean, I don't see any privacy analysis. I don't see any equal protection analysis. I mean, those things were pled, and I don't see a citation to cases that address.
All of those issues, Your Honor, are addressed in the Wakeman decision and in the Lamarata decision. These are
arguably not in this particular context where he is.
Well, you're creating a new situation, though. If we're going to let a woman donate female genetic material and create some special judicial right in that situation and not do it for a male donating male genetic material, you've created, the court would create an equal protection problem and would create a privacy problem and would create a constitutional problem.
But in those situations, the male intends to donate the sperm and then walk away. He doesn't intend to be the father of the child.
Lamarati intended to be the father of the child. He participated in it.
Let me get back to my question about summary judgment. You indicated, and I think the issue of the donative intent was before the trial court, and you said, well, we don't have anything to rely on to support my position that, well, maybe that wasn't a donative intent. We don't know because the trial judge never ruled. If that's the case, how was summary judgment appropriate in this case?
Because even if there wasn't, because intent is not the issue in procreation issues. We do not allow intent to be the issue in these kind of cases.
You were arguing before about being a donor. That you donate the egg, and then the woman that donates the egg loses all right to it, and that it's the birth mother that has all the rights. And my question to you is, well, I'm not sure that this was a situation where she actually donated the egg for purposes of walking away from any parenting rights. And you indicated, well, then the issue of donation and donative intent was never addressed by the trial court, but it was certainly raised by them. So if that's the case, donation certainly is a relevant issue in this case, according to your argument.
Your Honor.
Isn't it?
I think it is a donation situation. But even if it isn't a donation situation, it is not the court's inquiry, the trial court's inquiry as to the intent of the parties. We have a situation very clearly that's analogous in paternity law, Your Honors, in which a situation where a gentleman may intend to have a good time one night, but actually creates a pregnancy. His intent was one thing,
your
but
position is that as a hard and fast rule of law, that any time that there is a same-sex relationship between two women, and one woman donates her egg to the other woman with full intent that they be parents together to the child that's to be born, that in situations like that, once that transfer is made and the woman gives birth to the child, and that's it for the lady that gave the
biological material. Yes, sir.
that's
Absolutely.
I mean, no matter
And that's because the statute treats all donors the same. The statute doesn't provide for an inquiry as to what your intent is after a child is born. The statute says you give up all parental rights.
That's correct, as did the consent
And
she
you can't
signed.
modify it by contract.
You cannot modify it by contract. You very clearly,
There is
that
no
is...
solution to the donative, the egg donor. She has no possibility of having a legally recognized parenting authority over the
even though she's a biological mother.
either contractually, constitutionally, or statutorily.
And you're opening up, Your Honor, a situation of a gentleman that donates to a sperm bank and comes back 10 years later and says, I'm number 242 and I want to have visitation rights with your 10-year-old daughter. It's very clear that the donation of genetic material does not create a legal parent.
And I guess that's the same for a woman who cannot have children. I don't know, maybe she has health risks so that if she bore the child, she might die because of diabetes or something like that. If she donates an egg and tries to get a surrogate, I mean, she really is taking a chance that ultimately she can adopt that child, but she has no legal right to. Is that correct?
Well, I think that surrogacy fact is a little bit different because, first of all, you have the man and the woman as the commissioning couple, which is defined by the statute, and you have a specific statute that permits that type of contract to be done. And I don't think that's what we're talking about here. I don't think this can be a commissioning couple because and you always take legislation. You don't have to define every word in the statute. You take it by clear meaning. Man and woman is man and woman.
The donor of the egg wants to find a surrogate mother
Correct.
Because she as a single lady wants to raise a child. Does the statute provide that she can?
Absolutely. There is a specific provision for a surrogacy situation. She can have an fertilization of herself or of somebody else.
So in this situation, your client, if she had agreed to, could have given up any rights that she had and could have acted as a surrogate for his client.
Of course, a legal parent in any scenario can give up their parental rights in an adoption scenario. There's any number of scenarios. But in this situation, Appley did not give up those rights. She's got the constitutionally protected rights. She has the statutorily protected rights. Anything that the court would do about what they're intending or what they're doing would create a parole evidence situation against clear and convincing provisions in an agreement and contract. It would create
There are certainly conflicting provisions in that contract that would lead a reasonable person to conclude that that contract was not intended or designed to involve situations like this. Wouldn't you agree?
I'm not sure I would. I think that Judge Monaco read the very clear language that it was a donation and a waiver. But even if it wasn't a donation, even if there is ambiguity, there still is no position for intent in these types of determinations. There's only one situation, and it's statutorily created.
So, excuse me. So if the situation was reversed and the same-sex partner that gave the egg was the one that took the child and went to Australia, you're saying then that the other same-sex partner that gave birth to the child would have all the rights to get the child back?
Absolutely. The only time that the birth mother is not the legal mother is in a specifically legislatively created exception, which is the surrogacy situation.
So it's the birth mother that trumps the biological mother every time?
Your Honor, that's been the ruling from Staley and Carey and Roe and into the Florida Supreme Court cases, and the same thing. It's been the ruling of this court in the DE versus RDB situation, which I know is not a mother, but it is exactly analogous, which is that.
Can you give me one case, just one, from anywhere, where two same-sex partners who are women wanted to have a life together and wanted a child, and one donated the egg to the other. They had the child, and then the birth mother left, and the other mother sought rights, visitation rights, and parenting rights to the child. Can you give me one case where anywhere in the country?
I'm only familiar with Florida, Your Honor, and I know there is not a Florida
do you have
case.
any case from anywhere? Are you familiar with anything?
No, sir. This is a Florida law decision, and that's what we're arguing.
Maybe we can ask your opposing counsel in rebuttal if he has any.
Thank you very much, Your Honor.
Thank you.
You got anything from anywhere? Anything this is it?
No.
We're the first?
This is it.
Oh,
It's as far as I can tell, it has not come up, and
It's shocking.
Yeah, really.
I'm just amazed that it has not come up before.
there's law review articles, there's discussions about these issues, but nothing really seems to square with what's happened here. I can't imagine that it hasn't happened, but it has not been brought to the attention, as far as I know, any of the courts.
Well, it's so unusual because, this is a case where, frankly, from my perspective, all the equities are with your client, and unfortunately for you, all the laws with the opposing client. I've never quite come across anything exactly like this before.
I guess, and I hope this, well, it probably isn't going to make anything a whole lot clearer. Donation is not defined in 742.
Was donation an issue raised in the trial court below?
Yes.
Okay. And the trial court never addressed it, did it?
No, it was never ruled upon.
All right.
So, if there are no other questions,
Okay.
all right. Thank you.
Guys. A
Thank
very
you
troubling
both.
case. Thank you all for
Very much
your
well
help on this.
argued on both sides. Thank you very much.